Watcher Crypto GB. This article written by Hassan Tyler was cited by John E. Deaton from Crypto Law, who represents 75,000 individuals from around the world who are taking a class action against the SEC in the SEC versus Ripple case. And having read it, I think it's a really good summary of where we are today. So I thought it might be worth reading this out to the team at Crypto GB. So let's try and go through this. The title is SEC versus Ripple. Did the government fail to prove its case? The saga for what Forbes called the cryptocurrency trial of the century looks as if it is about to enter its closing stages. Final briefs on summary judgment were filed in November of last year by the US Securities and Exchange Commission, the SEC, and the payments software company Ripple Labs in SEC versus Ripple. Nearly 2 years of arguments are now in the hands of Judge Annalisa Torres of the Southern District of New York, who is expected to rule sometime in the first quarter of this year. SEC versus Ripple. The issue revolves around how Ripple uses the XRP token and its decentralized ledger as a tool for its cross-border payments software that it sells to international banks and money transmitters. The company and two of its executives sold large amounts of the token to exchanges starting in 2013, which fed a substantial secondary market for the cryptocurrency and an ecosphere for the XRP ledger for businesses and individuals without the involvement or permission of Ripple. That's quite important. The fact that it didn't involve it had no involvement or permission of Ripple to do that. Legal dispute is rooted in different interpretations of the so-called Howey test from the 1946 Howey decision from the US Supreme Court, which defined whether a financial instrument should be considered an investment contract and therefore a security, the investment of money in a common enterprise with a reasonable expectation of profits to be derived solely from the efforts of others. The SEC based its December 22 lawsuit on the contention that under the Howey test, the XRP token has always been a security because its only purpose is as an investment in Ripple as a company. This means that the token itself is a security, not merely in the manner that Ripple and its executives sold it, and all sales of the token have been unregistered securities trades from inception to present day, including on the secondary markets. The defense countered that XRP has more uses than Ripple's software product, and it is more a commodity, not an investment in their company. They also used market history data to argue its value is not tied to Ripple's success or failure, and that it operates on a decentralized ledger which will continue to exist even if Ripple closes shop. Ultimately, the burden of proof is on the SEC to prove its expansive legal theory that a digital token itself is a security, no matter who holds it. And investment contracts can be struck without the vast majority of purchasers knowing about the alleged common enterprise or the many unrelated use cases the token can fulfill. Most legal experts and crypto practitioners who have followed the landmark case appear to believe the US government failed to prove its legal theory for bringing the enforcement action. Further, they believe Ripple's defense team has raised serious doubts around the regulator's broad application of a nearly 80-year-old Supreme Court decision to decentralized cryptocurrencies and blockchain networks. Ripple's side has been boosted by an unusual number of filings from amici curiae, or friends of the court, including the Blockchain Association, the Crypto Council for Innovation, and the publicly traded crypto exchange Coinbase, who all opposed the sweep of the SEC's legal theory. Businesses that use XRP as a utility token for settlement of transactions in Bitcoin or fiat currency also contradicted the SEC's allegation of a common enterprise with Ripple. XRP holders opposed the SEC's complaint. A long-anticipated amicus brief came from a class of over 75,000 XRP retail holders from around the world who opposed the SEC's complaint. They attacked the SEC's shorthand and analytically lazy contention that Ripple has engaged in the functional equivalent of a 9-year-long ongoing 24/7 ICO, initial coin offering, and that each and every sale of XRP from anywhere in the world offered by anyone, including amici, was, is, always has been, and always will be the offer and sale of a security. As part of its summary judgment motion, Ripple submitted 3,000 affidavits from XRP retail holders who told the court they never heard of the company when they acquired XRP, and I was one of them. J.W. Verrett, Associate Professor of Law at George Manson's Antonin Scalia Law School, apologies for any mispronunciations, found Ripple's arguments to be stronger in interpreting Howey, and that any SEC victory now will likely be thrown out by the Supreme Court on the major doctrines question. Verrett called the legal theory at the heart of the SEC's lawsuit obsequious. Kurt Levy of the Federalist Society agrees with Verrett's assertion that the current Supreme Court would take the Ripple case on appeal to review Howey's application to digital assets, ideally ruling that decentralized cryptocurrencies don't meet the test. Levy writes that the Howey test is a poor fit for crypto because buyers of cryptocurrency are typically unaware of and don't care what third party first created the crypto token or decentralized blockchain. They use tokens for digital payments on networks and for access to smart contracts and decentralized apps, among other things, he said. Forbes columnist Rosalind Layton criticized the SEC's contention that Ripple, its executives, and the whole market should have known that XRP was a security back in 2013. She notes that after a long and bitter discovery fight in court, Ripple's defense obtained documents that showed the SEC was internally unsure about whether XRP was a security and gave vague and unclear guidance for years. Ripple didn't need to look too hard to document how the SEC had repeatedly waffled before the market participants for years over whether XRP was a security. Layton wrote, yet it now alleges that Ripple and everyone else in the market should have known anyway. Florida attorney Jeremy Hogan, who has followed the case on his popular television show on YouTube, believes the SEC's arguments have fallen short and that Ripple will win at summary judgment, in large part because Ripple had no legal obligation to purchasers of XRP after the sales occurred. He cited an extensive amicus brief from the Wall Street investment firm Paradigm, which argued the SEC failed to meet the investment contract definition on XRP sales. The last year has made it abundantly clear that the cryptocurrency market has more risks than investors had previously recognized. The SEC doubtless feels a modicum of political pressure to help investors to be better informed of such risks. However, categorizing XRP as a bona fide security will do little to accomplish this task. And by Hassan Tyler, as I stated earlier. This is a great article. I think it's a wonderful summary of where we are in this case and includes the opinions of some of our learned friends in this field. And you can see just how ridiculous the SEC's case is. I mean, I don't know how much money they've spent on putting this together, but it's, I feel sorry for US taxpayers who are paying for these criminals to come up with this nonsense. Anyway, I thought that was a great article and I wanted to share it with you.